the court has had a technical issue already. You guys didn't even see it, and we fixed it. So I won't say what it was, but it did involve Judge Smith anyway. So.
And it's somewhat obvious.
you look like an astronaut, Judge Smith, but that's good too. Okay, Ms. Cochran, you're up.
Thank you. May it please the court, my name is Jessica Cochran, and I represent the petitioners who are the defendants from the underlying case, Dr. Kozma and CRNA Everhart. I'd like to request to reserve 5 minutes for rebuttal, please. Thank you. Your Honors, I'm here today requesting the court quash the trial court's order denying our motion for summary judgment, in which it was argued that the plaintiffs failed to comply with the medical malpractice.
Can we start with that? You said quash, so this is cert. Is this an argument about compliance with pre-trial requirements, excuse me, or pre-suit requirements, or is this an argument that the statute of limitations was blown?
It's a little bit of both. It's an argument that they
failed
to comply with pre-suit.
Or is it ultimately that you didn't file in time? In other words, the statute of limitations requires that an action be commenced. And I went over 766.106 and I tried to look at it as the notice of intent being the action commenced, but that's impossible to reconcile because the 60 days talks about filing suit, and that's what Chapter 95 talks about. So it sounds like your argument is always that the statute of limitations was not complied with because they did not file their notice of intent timely. But the statute of limitations has to do with when you commence an action, and you don't commence an action, even under 76.106, by filing a notice of intent. The notice of intent tolls the statute of limitations, which is a period in which you have to file an action. So by characterizing your argument that, hey, well, what this really is a failure to file a notice of intent timely, there is no notice. There's no notice. You can file a notice of intent whenever you darn well please, but you better do it in time so that you can file the action within the limitations period in Chapter 95. So isn't that your argument? It's a statute of limitations argument, and isn't on cert that not cognizable?
Sure, but under Chapter 766, it requires you to serve a notice of intent and comply with pre-suit within the realm of 95.11. So it's essentially, you have to also serve a notice of intent before the statute of limitations ends. And although it does toll during that period, then you have to also file the complaint within the remainder of your statute of limitations. My argument here today is that they failed to serve petitioners with a notice of intent prior to the expiration of the statute of limitations. Obviously, if you fail to serve a notice of intent within that time, you obviously fail to file the complaint within that time, as the complaint comes after the notice.
Okay, so I anticipate you'd say that. That's what the statute says. Is that remediable on plenary appeal from the final judgment?
Yes, Your Honor, it is. And I'd like to point out that this issue has actually already been handled, as respondent did file a motion to dismiss based on jurisdictional argument, and we filed a response, and that motion was denied.
But we can change our minds.
Okay, well, and I would point the court to the case that I cited in my response, which was Cora v. Rehab, I believe. The issue with that case was the exact same here. It was a petition for writ of cert, and the trial court denied a motion for summary judgment for the same exact argument, that they failed to pre-suit prior to the statute of limitations. The jurisdictional issue, that is the same thing if it's a motion to dismiss or a summary judgment motion. It's the point of pre-suit is that you have to engage in pre-suit prior to even allowing the defendant to be subject to a lawsuit. In this case,
but your argument is that didn't happen timely. And what is the law thinking, to quote The Simpsons, that requires you to do that timely?
It's Chapter 766.
No, it's Chapter 95, which is a statute of limitations. There's a limitations period statute.
Right. Chapter 766 cites to 95.11 in saying that a notice of intent has to be served prior to the expiration date given in 95.11, which is those 2 years.
So why is this? So okay, let's say that as you started out with, you're right. It's a little both. Now let's just get back to the standard, which is we're not allowed. We don't have jurisdiction here unless it's something that is not remediable on plenary appeal. Why is it not?
And it's because there would be irreparable harm if it's not handled today, because the defendant, the point of pre-suit is to avoid a filing of a lawsuit if there are claims that should not be filed. If the claimant doesn't properly engage in all requirements of Chapter 76, there are multiple requirements, one of them being that the notice of intent has to be served prior to what's given in 95.11, which is the 2 years. If this isn't heard until later, the point of pre-suit is that they should never be in a lawsuit. Obviously, it's irreparable harm to make them go through this lawsuit when they shouldn't go through it in the first place.
Isn't the point of the notice too is to give the defendants the ability of the 90 days to investigate the claim? Is that what you're arguing would be irreparable harm?
Sure. The point of the notice is there's multiple points, is to give them notice of the claim so that they can investigate and decide if they want to settle the case within those 90 days. Obviously, if it's not timely, you shouldn't even be engaging in those 90 days of settlement. The statute of limitations has expired. It's also for the point of weeding out frivolous claims. Frivolous claims means multiple things.
The point is to weed out frivolous claims. Let's say that you won, let's say that they just went forward. Well, it did go forward. You got all of the benefits of the pre-suit procedures. Right? You did.
No, we didn't get the benefit of undergoing pre-suit prior to the expiration of the statute of limitations, which is one of the benefits of pre-suit.
Well, that sounds like a statute of limitations defense. It doesn't sound at all like the rationale for, in other words, the prejudice that is irremediable doesn't exist here. The case law, and to borrow from Judge Smith's point, the case law talking about what is the actual irremediable prejudice, which is not be able to avail yourself as a defendant of the pre-suit investigation and et cetera, and the negotiation, et cetera. It doesn't exist. That all happened.
Sure, but it's similar to if a plaintiff doesn't comply with some other part of pre-suit, if they don't give you an affidavit.
It's similar. Let's talk, before you say it's similar, let me ask you a threshold question. If in general, the case law is that, 766 pre-suit requirements give rise, failure to comply with them give rise to a cert petition. Can we get more granular, or do we just have to say it has to do with 76.106 pre-suit requirements, therefore it's cert worthy? Or can we say it's important which of the requirements were violated to determine whether, as we ought to do, as the officers who should only work within their own jurisdiction, whether there actually is a remediable harm from the violation?
Sure, and I think it can be, I think the position is essentially any non-compliance with pre-suit is irreparable harm if the lawsuit is permitted to go forward, because that is a right that Chapter 766 gives to all healthcare providers, is that they have the right to undergo the entire pre-suit period prior to a statute of limitations.
Well, the concern I have, Ms. Cochran, is kind of piggybacking on what Judge Atkinson is getting at, is that it seems to me that the expiration of the statute of limitations didn't deprive you of the opportunity to investigate and settle. It might have deprived you of the incentive to. You might have had it in your back pocket, but I don't know how that is irreparable harm.
And Your Honor, I would argue that's similar. If I knew from the get-go that this was a statute of limitations issue, I'm not going to recommend my client settle something in the 90 days if I think it was not complied with.
Right.
So
that's on the basis of an issue that can be resolved on an appeal from a final judgment. You got that far, correct?
I don't think it would be, because there would be irreparable harm. You would have the defendant would undergo the entirety of the litigation, which, as I'm sure Your Honor knows, would most likely end in a settlement, because most men mal cases do end in a settlement. If it did go to trial,
and the legislature, the whole purpose of the pre-suit notice is to encourage settlement, correct?
Exactly, it is, but you don't encourage settlement if someone files a lawsuit or serves a notice of intent after the expiration of statute of limitations, because you have that defense. Why would you settle a case if you think you can get it dismissed?
So, okay, so incurring the expense and trouble of lawsuits is never irreparable harm, unless you shoehorn it into specific policy statements that are created and implemented by statute, which is the legislature said you don't have to go through the lawsuit unless a plaintiff jumps through all these hoops. So here, the plaintiff did jump through all these hoops, and Judge Northcutt's point was different than I think what you described, which is, well, you still had to go through the lawsuit. Judge Northcutt's point, and maybe he wasn't making the point, but I'm capitalizing on it, is that you were denied the defendant was denied the effective utilization of the pre-suit procedures. In other words, it wasn't effective for its purpose, which is to encourage settlement, which is to encourage an adequate assessment of the claim in an environment in which there would be an incentive to settle it.
Correct, and that's exactly what the irreparable harm is.
Yeah, that wasn't in your brief, so explain it a little more. Maybe it was, and I forgot it was in the argument at the time of the motion to dismiss, but I can't remember.
Yeah, the motion to dismiss, but I didn't include it in my brief since it was.
No, I know, but reiterate that argument,
sure,
to the extent it was or wasn't included in your response to the motion to dismiss.
Sure, and I believe the point of Chapter 76 pre-suit requirements and the legislature's intent in having parties engaged in this is for multiple reasons. One, it's to weed out frivolous lawsuits, and that, as you know, is by the requirement of the expert affidavit. Another point of it is to have the parties engage in early settlement negotiations and a full analysis of their claim to determine if they want to settle prior to subjecting a healthcare provider and a patient into undergoing litigation. And that point of pre-suit cannot be complied with or fulfilled if the pre-suit 766 requirements are not completed prior to an expiration of statute of limitations. If a notice of intent is served after the 2-year statute of limitations, then why would defendants engage in settlement negotiations? Why would they consider settling when there is a defense that the notice of intent in the complaint shouldn't go forward? It doesn't, and it's the overall sort of purpose of 766 just doesn't get complied with or fulfilled if you allow it to move forward through a lawsuit.
Is there irreparable harm where the notice isn't served and the ability to discuss either settlement or investigate the claim happens outside of the 2-year statute of limitation?
Yes, there is, because as you all likely know, if you're discussing settlement and negotiations early on in pre-suit, you haven't incurred all of the fees and expenses of litigation.
Well, outside of expenses, I mean, don't we have issues with witnesses and the lapse of time and memories of things that happened? Is that something that we could consider as irreparable harm?
Sure, and I think that's a great point. I think that can also be considered, and that's sort of, the reason of having 766 and also having a statute of limitations. And I wasn't necessarily pointing out fees and expenses of litigation as a irreparable harm. I was pointing it out as once you go through litigation and then you engage in settlement negotiations later down the line, it's typically going to be a much higher number than it would have been in pre-suit when you don't have those fees and expenses. And that's why they encourage early settlement negotiations during that 90-day period, because typically you can settle the case for much less than you could 2 years into litigation. And we don't get that opportunity because it was after statute of limitations, and we wouldn't be engaging in those settlement negotiations.
So your argument is that your harm is that you had an incentive either to not settle or to settle for less because you had the statute of limitations defense in your pocket.
Correct. The
I don't see how that's harmful.
Because we would basically miss out on the opportunity to engage in early settlement negotiations.
To miss out on an opportunity to settle it for more.
To settle it for less.
Because we didn't get.
Well, let's look at the statute though. It isn't. I mean, don't we have to weigh that this was also intended to provide access for the plaintiffs to court? I mean, isn't that also something, as opposed to let's make sure the defendants get to settle these cases cheaper than they would otherwise later? I don't know that that's something that irreparable harm would meet the criteria here. But let me get past your jurisdictional argument and go to the substantive issues on the timing, because here there was one notice of intent that was set, pre-suit notice that was set to other defendants. You're the second set of defendants, right? Okay. Yes. And so the way that I understand that the court construed it was allowing, when the notice was served, that there was an additional 90 days that got tacked on.
It's additional 60 days, they're saying.
Well, they get the 60 days when the termination occurs. They get the greater of the whatever's left in the statute of limitations, which was less than 60 days. So they would have had the 60 days to file suit. Now, right. And so the conundrum here, I guess, would have been, well, there's not 90 days for your defendant. So my question to you then is, could the plaintiffs have served your defendants even though they had the 60, if they filed it within that 60-day time frame? Because your defendants would then have had 90 days, theoretically. I'm just asking, what would your position be? Would they not be allowed to file the pre-suit notice to your defendants within that 60-day time period? Or did they have to file suit and then they just forwent filing suit against your defendants?
No, so the 60 days that is provided for in 766.1064 is the time after that 90-day pre-suit period within which you were given to file suit against that potential defendant you just underwent pre-suit with.
Can I point out here that we have gone into the Ms. Cochran's rebuttal time. If you want to save your rebuttal time, Ms. Cochran, I'm not going to count this against you because the court took you there. But if you want to save 5 minutes, you should stop now. From henceforth, I'm going to count this against your rebuttal. How's that?
If I may just very quickly, and then I'll save the rest for my rebuttal. The argument that plaintiff or that respondent is making here is that after the first 90-day period that they had with the surgery center, I'm agreeing, give them that 90-day tolling period that Salazar allows for, the Salazar case. Okay, give them that. But then they only get the remainder of the statute of limitations to serve petitioners with a notice of intent. Their argument is that they get the 60 days to serve us with a notice of intent. That 60 days under 766.1064 is the time within which to file a suit against those potential defendants they just
served
with. Correct. It is not. There is the plain language of the statute simply says that the claimant shall have 60 days or the remainder of the period of the statute of limitations, whichever is greater, within which to file suit. They don't use the term tolling or extension. They certainly don't say that the 60 days is provided for them to then go find additional potential defendants and serve another notice of intent.
What if they had already, what if after the notice of intent to initiate litigation against the original defendant had been filed, tolling, and a period during which all potential defendants, it's told as them, what if they fit within the time of that filing of notice of intent to initiate litigation and the end of the 60 days, a filing of a notice of intent against the other potential defendants and a filing of a lawsuit against the other potential defendants?
As long as they serve the second group of potential defendants within the statute of limitations, it's fine. They can do that and file a complaint.
So so you're saying the plaintiff gets, if the plaintiff timely served the notice of intent on the other potential defendants for whom the statute of limitations was told, at least you'd say at least for the 180 days, right? The 90 plus the stipulated 90. Mm-hmm. What do those new potential defendant, no longer potential, actual defendants, for those, does the plaintiff have the right to avail itself of the 60 days after the end, after negotiations are terminated?
Yes, and that's correct.
Okay.
The plaintiff only gets those 60 days one time as to each group of potential defendants, and it is a grace period within which to file suit. It is not an extension to a statute of limitations within which to serve additional potential defendants. Right.
It's okay. So, but it's a grace period. There's only one statute of limitations per incident. It may be told differently for different defendants, but there's one limitation period. Whatever happened once, and there's a 2 years plus the time you get. So you're saying that 60 days, they could, after the night, let's say that the pre-suit took up the whole 90 and then the whole stipulated 90, 180 days is gone, negotiations fail. You have 60 days to serve any plaintiff, even if it wasn't the original plaintiff, if they were served with the notice of intent 90 days before you ultimately file suit. You have those 60 days. Is that correct?
As long as they did serve them and go through pre-suit, then yes, you have 60 days to file a complaint. And in our situation, they didn't serve my potential defendants with a notice of intent.
You can't start the whole process during the 60 days. You have to actually serve a complaint. Yeah.
Correct. And the plain language of the statute, as well as I think the only case that really discusses this issue is the Okaloosa v. Custer case, where the first CCA found and agreed with the petitioner that the 60-day period does not hold the limitations period further for purposes of complying with pre-suit requirements. And that case,
your rebuttal is down to 2 minutes.
All right, I will. Thank you. I'll save
do what you want. All right, thank you. Majewski, you're up.
Good morning, Your Honors. Annabelle Majewski, representing Ms. Rosa, and by extension, the surgery center. It's a please the court. My first point was been already debated extensively by Judge Atkinson, but just to reiterate, I filed a motion to dismiss saying that this was not a case for certiorari because it was actually, they moved for summary judgment on one of their affirmative defenses, which happened to be a statute of limitations defense. And my argument was that statute of limitations denial of a summary judgment on that basis is not right for certiorari because it can be remedied on final appeal. The other thing is that the irreparable harm that is being claimed here, as she said many times, is litigation expenses, which her argument that now they would have to settle for more money, that's a litigation expense. So that's not irreparable harm. In Panagakos versus Lawfer, this court also cited to Whiteside v. Johnson that certiorari is not a writ of expediency and an adequate remedy on appeal, on final appeal, is available for a denial of a statute of limitations defense.
Ms. Majewski, let me ask you this: on the cases that you are citing in support of the motion to dismiss, are any of those cases, do they deal with the pre-suit notice issue that we have here?
There was one that briefly mentioned that if it was a failure to file a pre-suit notice, then that is adequate for certiorari. But in this case, we did file a pre-suit notice. It's just that according to the petitioners, it was past the statute of limitations. So it really is a statute of limitations defense. And yes, the court did deny my motion to dismiss, but allowed me leave to again argue it today, which is what I'm doing. To move on, since we're going a little long, if you look on page 4 of my response to their petition, we have
Counsel, did you address the argument that we were all sort of discussing that it deprived? It's not a litigation expense that they it's not just the fact they might have settled for more, but the deprivation of effective use of the pre-suit procedures because, you know, to put words in the mouth of opposing counsel, they have a statute of limitations defense in their back pocket, so they're hamstrung in their decision making on whether to settle. Because why should we settle something that is time barred? Is that the same type of harm that's irremediable in those cases in which, for instance, they didn't even have a pre-suit investigation?
Well, that's right, because the cases where it's certiorari was granted, there was no pre-suit. They didn't have a notice of intent served in some of them, and there was no chance for a pre-suit investigation. In this one, the defendants were served with the notice of intent, and then they had 90 days to investigate, and then they denied the claim. And so then there was 60 days after that before the complaint was filed. So we're talking now, what, 150 days, where if they wanted to settle, they could have made an offer, and that takes care of their argument that now they missed the opportunity to settle the case for less money, and they are irreparably harmed by that. That still goes to the fact that it was a litigation expense, and that the pre-suit notice is to give them a chance to investigate. In this case, the complaint against them was not filed until 150 days after they received the notice of intent. And going back, the calculations that you will find on page 4 of our response all coordinate with 766.1042, 766.1063 and 4. And the calculation.
Well, how did they do that? If there are, as of shows here, October 22nd, 2018, that there were 12 days. Well, let me ask you this first. Do you agree that there were 12 days remaining in the statute of limitations, which included the purchased 90-day extension? Is it, I mean, whatever date it is, it was, do you agree it was 12, or if not, what time frame is your position on that?
I'm going to say November 5th. They brought us to
the 90 with the purchase. Okay.
Yes. Yes, November 5th would have been the 2-year statute of limitations plus the 90 days purchase. And then,
so you have that 180. Go ahead, Judge. Sorry.
No, I was, so when the denial of the claim came, how many days were remaining under the statute of limitation? Because the time period would have been told during that, before the end of the statute of limitation period. So when the denial claim letter came,
by that time, I think they would have used February 1st of 2019 would have been plus. they would have gotten 60 days because it was the greater.
Sure. Okay. Okay. But the 60 days isn't an additional time period to tack on to the statute of limitations. That's within which to serve the lawsuit. So,
correct.
Okay. So the notice of intent was served on to your clients, to the defendants here. And when the initial 90 days and the 90 days and the 2 years, okay, when that ran and the denial of the claim letter came to your clients, there were 12 days remaining. Didn't you then have only 12 days left in the statute of limitations period to file your pre-suit notice on the defendant, on the petitioner here?
No, Your Honor. And
okay, then show me in the statute, because I don't read the statute quite like it is raised in your brief and as the trial court applied here.
What we've moved on to is that was the point number 3. After the fact that these calculations are correct as to defendant ACS, the surgery center. And so then that brings us to the final wrapping up, the fact that since the notice of intent and the complaint against those defendants applies to the timeliness, also applies to all potential defendants. And that is the language of the statute. Let me find it. And it's again discussed amply in by the 3rd DCA in Salazar v. Coelho, which is 154 Southern 3rd 430. And they rely on Cora Health Services v. Steinbraun, which is 867 Southern 2nd 587 from the 5th DCA, that the timely notice of intent holds the time as to all potential defendants, and they cite to the.
Okay, so but the words there are a timely notice of intent. And so where the notice of intent here was served after that 12-day period that was left when the statute of limitations expired, the notice here would not be timely. The only way the notice here would be timely is if you were to add the 60 days. Is that right?
You lost me, Your Honor.
Okay. Well,
what we're saying is that 766, if it tolls the time as to one defendant, it tolls it as to all potential.
It tolls the statute of limitations. So when the first set of defendants that were served then gave their denial, that statute of limitation period was no longer tolled because it cuts it off. So then you calculate the remainder of the statute of limitation period. And from what I can tell, there were 12 days remaining within which your client then had to serve the pre-suit notice in order to get the benefit of the tolling of the additional 90-day investigation period. But I think what your position is, and this is what I want to make clear, your position is that they had 60 days because that added to the statute of limitation. And what I'm saying to you is I don't see that from the statute, that the 60 days is an extension or a tolling of the statute of limitation period, where a timely notice isn't served within the statute of limitation period.
Well, Henke v. Yarian says that it does interrupt and suspend the running of the limitations period, the section 766-1064. If there are less than 60 days remaining to file suit before the end of the original 2 years limitation, at the time you file your notice of intent, then the claimant shall have 60 days from the time when the notice of termination of negotiation is received by him to file suit. So we filed the notice of intent before the statute of limitations ran, and then you go back to the denial of the claim letter was received on January 17th, which gives 60 days to file of the lawsuit against ACSC. But what we're saying is that the tolling applies to all potential defendants. And so that not only was the notice of intent giving us 60 days.
Yeah, and I don't see the petitioners here saying that 90-day period didn't apply to the second set of defense. I don't hear them saying that.
No, Your Honor.
I could be wrong. Okay.
I don't think there's a dispute as to the fact that the surgery center is timely all the way around. I think the dispute here is whether that timeliness as to the surgery defendant also makes timely any service to all other potential defendants. And that's where we rely on Salazar and the third DCA, because the facts were almost identical. They had timely notice and a filing of complaint against one defendant, and it's the other defendants that were saying, well, wait a minute, it wasn't timely as to us. And the third district is saying, yes, it is, because the tolling applies to all potential defendants, not just the one that you actually served and filed against.
So let me ask you this. So you're saying, if we say that the 60 days extends the tolling, and the tolling applies to all defendants, then the other defendants to whom notice of intent had not been served, because the statute of limitations period was still told, the 12 days doesn't matter because the 60 days, it's now 60 days. Well, I guess that's okay. Then the other defendants, you're saying, can file a notice of intent, which would serve as an alternative tolling mechanism. And once the 60 days runs, it doesn't run for them anymore because it's not running for them at all. It's still told by virtue of their own notices of intent, or sort of their own 90 days.
Yeah.
But is that kind of your argument?
Yeah, it's the denial of the claim letter from the surgery center gave us 60 days.
Yeah.
All right, so that brought it to March 18th. And these defendants, petitioners, were served their notices of intent March 7th within that 60-day period. And that's what we're saying.
But the statute doesn't say you have an additional 60 days to serve a pre-suit notice. The requirement on the pre-suit notice is that it has to be filed within the statute of limitation period. And while the 90-day investigation period tolls the statute of limitation as to those potential defendants still have to be timely served. The 60 days just allows the plaintiff the additional time period within which to file suit, giving them the benefit of greater than whatever the statute of limitation period is left, because you could wind up after your investigation period and your purchase 90 days that you only have 1 day left to serve a defendant, which seems unfair, which is why they gave the plaintiffs the additional 60 days within which to file suit. So I don't see the 60 days as a tolling an additional period for these potential defendants that weren't timely served within the original statute of limitation period, which they did have time. There was 12 days left, it looks like, after the denial of the claim.
I think what we have in Hankey, what the court said was that the extension provided by 766-1042 is an extension of time to the limitations period. rather than a tolling provision. So it's the 60 days is added. So what you have here is you've got 2 years, then you've got the 90 days that you purchase, and then you've got the 90 days that you get after you've served the notice of intent, and the 60-day extension of time is added to the statute of limitations. It's not.
No,
let me ask this. How can you say it adds to it when it says the claimant shall have 60 days or the remainder of the period of statute of limitations? So those two are both not the remainder of the period of the statute of limitations. One is the remainder of the statute of limitations period. The other is 60 days. So, and at the time of the notice of termination of negotiations, the 90 days plus the 90 days, none of that matters anymore. All that matters is there are 2 time periods: what remained on the period of the statute of limitations or 60 days. And the use of the disjunctive or means those are not the same thing. The 60 days does not supplant what's remaining on the period of the statute of limitations. There's one limitations period, and it's going to end 12 days from the time of the notice of termination negotiations. And counsel for the defendants have stipulated that if the plaintiff had timely filed a notice of intent to litigate against new defendants, that those new defendants would have the 60 days, because the 60 days is within which to file suit against anybody.
Okay.
Right? But so, you can't also, so you either had the remaining period to file a notice of intent on other defendants, which would toll as to them, or you have 60 days to sue those other defendants who had been served with notice of intent at least 90 days prior to filing suit. The problem was that didn't happen. So the plaintiff did not have could not have filed suit, which is that's what commences an action, right?
Yes. The notice, yes. The notice of intent and then the 60 days and the 60 days. What we're saying is that according to Salazar, the tolling or the time period in which that we get after the denial of the claim letter applies to all potential defendants, not just the ones that have already.
Can I stop you there? Because that's kind of my point. I'm conceding, playing the devil's advocate on behalf of the defendants, that that 60 days does apply to all defendants, potential defendants.
Okay.
But how does it apply to them? It applies, you can sue them. Go ahead, sue them. But you can only sue those defendants for whom you have filed a notice of intent at least 90 days earlier. You can't, your suit's not going to work unless you've done that. So yes, so under Salazar, that 60-day period does apply to, quote, all potential defendants. But the difference is what you can do to those defendants.
You're right at 20 minutes, Ms. Majeski.
All right, let me quickly
say, can wind up.
Your Honor, that I can't sue all potential defendants if I have not served them a notice of intent. And so therefore, it should be that I can serve them the notice of intent within those 60 days and in order to commence the suit against them.
That's not what the statute says. The subsection 4 doesn't allow you to do that with the 60 days.
Okay. All right, Your Honor, then that's your interpretation. And I'll go back to reiterate my point before I ask you to affirm the trial court and dismiss this petition for certiorari. The fact that it is a statute of limitations defense is not appropriate on certiorari. And we do think that the 60-day extension or time period for filing after the denial of claim letter from the surgery center applies and suspends the time, shall we say, or applies that 60 days also to all potential defendants, and therefore these defendants were timely served with a notice of intent.
Thank you, Ms. Majeski. Thank you. Ms. Cochran, 2 minutes.
Thank you. Your Honor, just very quickly, I want to comment one last time on the jurisdictional issue. The case cited in our response to the motion to dismiss, Cora v. Steinbron, which is a 5th DCA case, is the exact situation that we have here today. And I'm quoting from the 5th DCA, Cora petitions for a writ of cert to review the trial court's order denying Cora's motion for summary judgment, in which it alleged that plaintiff failed to timely comply with the pre-suit notice required of a med-mal claimant pursuant to 766-1062. It's the exact situation that we have here today. And I want to again emphasize that.
But let me ask you this, Ms. Cochran. I was just looking back at your answer in affirmative defenses. You make a statute of limitations defense. You don't mention the pre-suit notice in your plea.
Sure.
So how do you get a summary judgment on something that's outside the plea? Did you separately move to dismiss?
No, it was statute of limitations defense based on the failure to timely pre-suit. So it is a pre-suit issue, and the summary judgment was argued that the notice of intent was not received timely under the statute of limitations.
Under the statute of limitations.
Correct, and the again the argument of being deprived of the purpose of pre-suit, and I'm reading from cited case law that these statutory pre-suit screening provisions are intended by the legislature to facilitate the expedient and preferably amicable resolution of med-mal claims. We wouldn't get that benefit because we would not have any motivation to engage in any amicable resolution of a claim when we have a statute of limitations defense.
So you were deprived of the benefit to pay money that you maybe didn't need to pay.
We were deprived of the benefit to decide whether or not we wanted to settle a claim early on, because we wouldn't have wanted to do that given the defense that we had.
Let me ask you this. Say there's a dispute as to whether it was timely or untimely under the statute of limitations. Don't you still have the ability to settle the case and in your calculations take into account the fact that that's an issue?
Of course you can. I mean, you always have.
So I don't know how this gets to be irreparable harm.
Well, because we didn't have the full benefit of it. The full benefit of it is to make that determination based off of our investigation, the medical facts, and the care and treatment provided. It's not based off on whether it's within the statute of limitations or not.
Well, how does it differ from any other defense you have in your back pocket? Let's say this was I'm sorry, I can't think of it off the top of my head, but you're always going to make calculations.
You get somebody to value a personal injury claim. And part of that valuation is going to involve, what are the legal issues that are out there that you could win or lose, and how strong or weak are they? Isn't that something that you still have the benefit of when you're investigating this claim, deciding whether to settle it? Is you have this statute of limitations, potential total winner, but it's not slam dunk.
No, I don't think you have that benefit. Of course, you can always settle a claim, whether it's a demand, a case.
Indeed. So the question is how are you irreparably harmed since you can always settle the case?
Because the point of Chapter 766, which does not apply to all personal injury claims, it's only medical claims, is that they are trying to facilitate early settlement of medical claims, and those are based off of the medical facts.
And somehow your ability to investigate this was cut off by the statute of limitations?
It's not ability to investigate. That's not my argument. My argument is it's the ability to fully engage in whether we want to settle the case early, and we didn't have that benefit.
Thank you.
And I just want to quickly touch on moving from the jurisdictional issue. I think Judge Smith and Judge Atkinson described it perfectly, that the statute does not provide those 60 days within which to extend the statute of limitations to then serve additional potential defendants with a notice of intent. If she had served us within those final 12 days or within the 90-day period during the pre-suit with the surgery center, then it would have been timely. However, those 12 days lapsed, And the 60 days that are provided after the surgery center's pre-suit period are only for the purpose of filing a complaint against potential defendants, which, as we know, you have to pre-suit first. And the
you should close now, Ms. Cochran.
All right, and in closing, to quote from Okaloosa County versus Custer, which again I believe is the only case that somewhat touches on this issue.
That doesn't sound like you're closing. Your closing is, well, thank you, Your Honor, as we request that you issue this writ of certiorari and quash it.
I apologize. I just
wasn't
on spending my entire argument on the jurisdictional issue.
I get it. I get it. We consume your time, but it happens.
That's okay. In closing, I request the court quash the trial court's October 8th, 2020 order and direct the court to grant the summary judgment motion. Thank you.
So like closing, Ms. Cochran. Okay. In order to leave our virtual courtroom, you need to click the leave